Ready, start. Through the judgment of the writ petition, Mukut Bihari Goyal and two others versus the state of Maharashtra, delivered on December 19, 2025, Justice Sushil M. Ghodeswar has at the Aurangabad bench of the Bombay High Court expressed his considered view that the JMFC Majalgaon has committed a manifest error of law in committing the case to the Sessions case, as the impugned order is contrary to the scheme of the Act and ignores the express statutory provisions governing the forum of trial. As such, the interference of the High Court is warranted para. The petitioners in this case challenged the order passed by the JMFC Majalgaon district bid, allowing the applications filed by the respondent prosecution and committing the case to the Sessions Court while issuing notice to the respondent on January 22, 2020. The High Court had granted interim relief, thereby implementation of the impugned was stayed para. According to the petitioners, they are having valid license issued by the drugs controller Jaipur, Rajasthan for manufacturing the drug lupizamine 200 ml para. On March 4, 2005, the respondent filed the complaint before the JMFC Majalgaon, alleging therein that he being appointed as a drug inspector under the provisions of Drugs and Cosmetic Act 1940 is authorized to institute the prosecution under Section 32 of the said Act para. It was alleged in the said complaint that on July 29, 2003, the complainant visited the premises of Messrs. Sri Krishna Distributors, Majalgaon, and drew the sample of lupizamine manufactured by petitioner number 3 company. After sending the drugs for analysis, the report was received from the Government Analysis Drug Control Lab, Mumbai, on October 16, 2023, wherein it was reported that drug is not of standard quality. It is therefore alleged that present petitioners accused have committed the offence under section 18A1, read with sections 16 and 34 of the Act, which is punishable under section 27D of the Act. According the complainant came to be filed para. The petitioners have further contended that on the basis of the said complaint, the JMC Majalgaon issued process by the order of March 4, 2005 against the accused petitioners. However, the respondent prosecution filed an application for committing the case to the Sessions Court, Majalgaon, alleging therein that as per the amendment to the 1940 Act in the year 2009, on August 10, 2000, the case will have to be committed to the Sessions Court at Majalgaon as per section 32, subsection 2 of the Act para. The petitioners have contended that they opposed the application in view of the fact that the case was filed in the year 2005. The amended Act and the provisions would not be application retrospectively para. It was further contended that in view of section 36A, the offence will have to be tried in a summary manner, as the punishment provided under section 27D is up to 2 years. However, the JMFC Majalgaon, through the impugned order of October 16, 2019, allowed the application, holding that Amendment Act 26 of 2008 will have retrospective effect, and section 32 subsection 2 clearly mandates that offences are triable by Sessions Court, and hence the case was committed to the Session Judge Majalgaon. This order brought the petitioner before the Sessions Court Para. After hearing the advocates for the retrospective sites, the High Court considered it pertinent that while passing the impugned order, the magistrate has in this case relied upon the amended provisions of Section 32, subsection 2 of the Act. Therefore, the High Court has considered it necessary for proper appreciation of the contention of the parties to discuss sections 32 subsection 2 and 36A as amended on August 10, 2009. Para. The conjoint reading of these two sections makes it abundantly clear that though Section 32 subsection 2 provides that no court inferior to that of court of session try an offence punishable under the chapter the same is expressly qualified by the words save as otherwise provided in this act. Section 36A is one such provision which saves the jurisdiction of the magistrate and mandates summary trial of offences punishable with punishment not exceeding 3 years, except those specifically triable by the special court or the court of sessions. Therefore, the jurisdiction of the magistrate to try offences under Section 18(1) read with Section 27D of the Act remains intact even after the amendment.